Okay, so we are going to finish up with the material before the midterm, and then we'll talk about the midterm. So we're on page 63 of the course materials, and we're going to talk about strict liability. So just as a reminder, you don't need to turn the page. There are three categories of tort law: intentional torts, negligence, and strict liability. So strict liability is the third category of tort law. And these are, again, separate and distinct types of tort law. So back to strict liability on page 63. So essentially, when we talk about strict liability, what we are referring to is essentially an idea that if you are responsible for an activity, and this will all be set forth in some very specific law, either a statute or an administrative rule of some type, that mandates strict liability. This doesn't really just happen. It has to be set in law because it's a very, in some ways it's a very, I don't want to say harsh isn't the right word, but it's a very limited area because essentially strict liability is sort of like no fault tort law. And what I mean by that is, compared to intentional torts and negligence, an intentional tort requires that the person does something intentionally. They commit a wrongful act purposefully. Negligence requires that the person violate a duty. So in both of those two types of torts, intentional torts and negligence, there is some action on behalf of the person that committed the wrongful act, either an intentional wrongful act or an unintentional but breach of duty wrongful act. Strict liability is different because this is the idea that there are certain areas as defined by law where it doesn't matter whether or not you were at fault. It doesn't matter if there was an intentional action by the person, whether or not they violated a duty. In fact, they may have been complying with what the duty was, but because the law imposes strict liability, if you are the person in charge of that activity, you will be responsible for any injuries that result regardless of fault. It doesn't require intent. It doesn't require a breach of duty. If you're the one in charge, you're the manager, the business owner, whatever the case may be, if you are the one in charge, if somebody is hurt, in some cases, even if the person that was hurt was at fault for their own injury, you are still responsible for payment of their medical bills, lost wages, and other types of expenses, depending on the area of law. And again, this is a very limited area because, typically speaking, the idea of tort law is that somebody committed a wrongful act and therefore they should be, in a way, punished for it, right? Or at least responsible for it, if not, I'm not sure punishment is always the right word, but you are responsible for your actions. Strict liability, you're responsible even if you're not at fault, okay? So, again, a very narrow area of law. This doesn't really apply most of the time in your everyday life. And again, there has to be some law, either a statute, an administrative rule, it could be city code, a city law, municipal law, or a county code, some type of very specific law that says, in this area, if there's an injury that results, the responsible party has strict liability. So there are three basic areas where we see these type of laws. The first one, letter A, is in an area where you are engaged in ultra-hazardous or abnormally dangerous activities, again, as defined by law. So this would commonly be in an area, probably the best example is the use of explosives. In mining, construction, demolition, fireworks displays, other type of use of explosives. That is typically going to be a regulated area for the most part. It will typically require a permit along with liability insurance, and you will be responsible in the event that there's any injury or property damage arising out of that activity, even if you were not at fault. So, you know, if I'm engaged in demolition and I'm going to take a building down using explosives, the law will impose strict liability. So if somebody gets hurt, you know, even if they go out and they grab the detonator or something and they blow themselves up, I didn't adequately secure the scene. I didn't adequately make sure that the explosives were not available to be picked up. I didn't have proper safety instructions or meetings. Doesn't matter. I could have been following all the rules, but because I'm the one in charge, I'm the one in charge of the permit, I will have strict liability. Now, another area where you'll see that is in animal ownership. This is a pretty common type of a law where if you're a dog owner or an owner of an exotic animal, like a tiger or something, oftentimes you'll have to have a permit for that as well. You are strictly liable. So if your dog bites somebody, you're responsible to pay for their injuries. That's a real common area. Now, sometimes it's really, really one-sided. I remember a case, it was in California, I can't remember exactly where, it was in the Bay Area, but there was a city code that said if you're a dog owner, no matter what, if your dog bites somebody, you have to pay for their injuries. Well, of course, what happened, somebody a burglar broke into somebody's house, and a dog bit the burglar. And the burglar sued the homeowner for the dog bite, even though they were, you know, basically breaking into their house. And under that law, you're strictly liable. Now, they've amended that, right? But the idea is, and that's one of the problems with strict liability, is you're basically assigning fault to someone even if they didn't do anything wrong. So it's a very narrow area of law. So ultra-hazardous or extremely dangerous activities, use of explosives, dog bites, or other type of animal ownership that leads to an injury. That's one area of strict liability. Now, the more common area is letter B, and that is if you are an employer, you have, by law, an obligation to carry workers' compensation insurance. That is insurance that will cover injuries that your employees may sustain in the course and scope of their employment with you. That law will mandate that you carry insurance, and the insurance will be based on the type of activity, construction, office activity, whatever type of work your employees are doing. It's also based on your payroll amount, and the more dangerous the work is, the higher your premiums will be. So if you're in construction, commercial fishing, very high premiums because it's very dangerous work, those kind of things. So the idea of workers' compensation is you as the employer have to provide that coverage. If you do not provide the coverage, then you are personally liable for any injuries that result. Even if you're a corporation or an LLC or some type of other business organization that provides a level of liability shield, workers' compensation is a form of strict liability. And I've seen this happen many, many times in my own practice. I had one recent case where the employer ran a meat packing company, and they forgot to pay their premium. They didn't forget, they had it on auto pay, and for some reason the bank switched up their auto pay, and so the premium didn't get paid, and so they dropped the coverage, and they didn't know about it. Of course, what happens? One of their workers got a meat hook, went into their neck. It was a horrible injury. And you know, the employer thought they had coverage, but they didn't because the premium didn't get paid. And so not only were they personally responsible for the injury, they also got fined by the state for not carrying coverage. And I've had many other cases where it was an intentional situation where they just didn't want to provide coverage to save money. I had one client that lost their house and everything else because they didn't want to provide coverage. Now, the other place where this occurs, just so you're aware, I'm not going to go into a lot of the specifics of this, but just so you're aware, when you hire somebody to work for you, there are two categories. They can either be an employee of yours, in which case you have to have workers' compensation coverage by law. The other way is if they're what's called an independent contractor. An independent contractor is someone that's engaged in business on their own, and they're doing services work for another person. So for example, maybe I'm a painter and I paint buildings. So you hire me to paint your office building. I do that type of work for lots of other people. I'm my own company. In that case, you don't have to carry workers' compensation because I'm not your employee. So this is a big issue because we're seeing, especially in the gig economy, like with Uber and all that kind of thing, we see situations where you and I may agree that you're an independent contractor, however, the law has the ultimate say. So we may agree, we may even have a formal written contract where you agree that you're an independent contractor, that I won't be covering you with workers' compensation, but if in fact you were acting as my employee according to the law, and this is both federal and state law, it can be determined that you truly are my employee even if we agree otherwise. And it can recharacterize the relationship between us as that of his employer-employee. Now typically this is based on a situation where you are doing work exclusively for me or very limited work for other people. You're using my equipment. I have the ability to tell you when and where and how to do your work. In other words, I have what's called the right to control. And in that situation, even though we say we're an independent contractor, the state can say no. This relationship is really more of an employer-employee relationship, and therefore you had to cover that person with workers' comp, even though you said they were an independent contractor. And I've seen that happen several times. Just so you're aware, in Oregon, there's a presumption that if somebody's doing work for you, they're your employee. And it gets into kind of a gray area sometimes, especially with remote work and other kinds of things, on whether or not somebody's your employee or not. What I usually tell my clients in my practice is, if you're able to tell them when, how, and when, the hours of work, that kind of thing, if they're using your equipment, if they're doing work for you pretty much exclusively, then you're an employee. You should always err on the side of them being your employee to be safe. If they have their own company, they're set up with their own LLC or corporation, they advertise to the public as a whole, you hire them to do like a one-time or limited time job, or a case-by-case basis kind of thing instead of ongoing, that's going to be more like an independent contractor because they're doing that type of work for other people. So when in doubt, you should carry workers' compensation insurance because the risk is so high for you personally. If you do not carry it, really the risk doesn't outweigh the reward. You might save a few $1,000s in premiums, but then somebody gets hurt. I had a case once where it was a truck driver operating as an independent contractor, and they lost their eye putting tire chains on going over the St. Anne Pass. They were putting chains on a semi-truck, and they had a big screwdriver, and they were levering the chains onto the tire, and the screwdriver popped out and caught the driver's eye and just took it right out. It was horrible. No workers' comp coverage. So it ended up that the owner of the trucking company lost their house, and it cost them about $500,000. So all because they didn't want to provide coverage. All right, so workers' comp, and I have that highlighted because that's the most common form of what we would call a strict liability type of a situation. Now this will vary from state to state, but pretty much all states now require workers' compensation at some level. With the workers' compensation, there's also, if somebody's permanently disabled, not only do you pay for medical bills, but there's a permanent disability payment, lost wages, and that kind of thing. All right, and then finally, letter C is a third area where we see strict liability, and that's in the area of defective and unreasonably dangerous products. So this is sometimes called product liability. And this is the idea that if you're a manufacturer or you're a producer of a good, including food. This is where we see this a lot with food, pharmaceuticals, automobile parts, other type of areas like that, where you have a product that's defective. You have an obligation, number one, to recall the product if you're aware of the defect, and you're also potentially strictly liable for any injuries that result. So let's say I'm a manufacturer and I make wheels for cars, aluminum or steel, it doesn't really matter, but aluminum, probably a better example. Let's say I have wheels that for some reason the aluminum in that particular batch of wheels is very brittle, more brittle than normal, and when it gets very cold out, let's say 20 degrees or colder, those wheels become so brittle that they will shatter at speeds above 70 miles an hour. So that's a defective wheel. So if I am aware of that, I, one, need to do a safety recall, and then two, potentially if the wheel shatters and they get injured, we would have strict liability to pay for those injuries. Even if they were speeding, violating their duty, I would have strict liability as a manufacturer. So that's called products liability, or manufacturer's strict liability for a defective product. And so again, that's going to be set by law and what your requirements are to follow through on that. And that's also, if you are a manufacturer, you're going to want to carry products liability insurance, which is insurance that would cover those type of claims. And that can be very expensive, as you can imagine, depending on the type of product and the type, the foreseeability and reasonability of the injuries that may come out of the defective product. Now, typically, products liability applies to a defective product, not to a product that may cause an injury. So for example, we see a lot of product liability type strict liability claims argued against handgun or other firearm manufacturers. If you have a defective firearm, obviously that's going to fall into this category. But if the firearm's not defective, strict liability doesn't apply. It's working as it's intended to work, albeit it's intended to injure or kill. Same thing with pharmaceuticals or tobacco products for that matter. That's where a lot of the arguments come out for tobacco products on a strict liability basis. So for purposes of the test, the midterm, I occasionally will ask this question as a fill-in-the-blank question. What are 3 areas where strict liability in tort law applies? And I will accept multiple answers here. If you say dog bite, that's fine. Abnormally dangerous activities, fine. Explosives is fine. Workers' compensation, employee injuries, those are alternatives, the same thing, I'll give you full credit. Defective product, defective manufacturing, product liability, all of those kind of go aside. Question? No, just, okay, sorry. Okay, so that's pretty much it there. So that's where the midterm line is. In other words, the midterm will cover from the beginning of the term up through that section. The next section we're going to go over is contract law. We'll do that next class session. So let's talk about the midterm. And I'm going to pause this.